Lordship, I'd like to make item number 4. Lordship, here we are yet to file affidavit in reply. So kindly grant us 2 weeks time.
You're for the petitioner.
Yes, I'm for the.
Okay. Your good name?
Abel Ayemi.
You are for?
Oh, CCT Malot. Union of India Malot. That and only.
Okay, so they are seeking time to file affidavit in reply.
Opposition Malot.
Okay. Mr.
Abel Ayemi.
Then counsel for the petitioner prays for how much time?
2 weeks time.
2 weeks time to file affidavit in reply to the affidavit filed by
All the CGC and state government and other
Okay.
respondents. will file.
filed by the respondents, to which the land council for Mr.
That and only Malot.
Then CG SC has no objection. Accordingly, the prayer is allowed. This is matter after 2 weeks. 2 weeks. Okay.
Last place.
Congratulations.
Yes, Lordship.
Yes.
Why not I'd like to mention and on this motion, if I may be allowed to.
What is this about?
My lord, this matter is regarding a contract matter, however,
Okay.
the contract is terminated and.
Probably,
petition-
no, tomorrow. Not as an unlisted
it's just
matter.
for withdrawal of
Let it,
Withdrawal of petition.
withdrawal of petition. Okay. Okay. Yeah, mention memo. Okay, please.
Please, Lordship. Lordship, I beg to mention item number 10, Your Lordship, in the
Item
orders.
10.
Yes, Lordship. Lordship, here we have instruction to appear on behalf of the respondent number 5, Your Lordship. So I pray that 2 weeks time may be given your Lordship, to file our reply, and in the meantime, we'll be filing our power in the course of the day.
You are for respondent number 5.
Yes, Lordship.
Okay. Petitioner. Okay. Mr. Yes.
Medovero.
Just a, you are Pogner,
Yes, Lordship.
counsel for the petitioner.
Your Lordship.
Mr. Medufero put appear on behalf of the respondent number 5
Yes, Lordship.
and prays for some more time to file power. How much time you
2 weeks time, Your Lordship.
and also to file affidavit?
Yes, Lordship.
Okay. Prays for 3 weeks times, huh?
Lordship, in the interim may be continued.
Okay, the prayer is allowed. Least is matter after 3 weeks. Stop. In the meantime, the interim order passed earlier shall continue.
Oblige, my Lord.
May please, the Lordship,
Yes.
may be pleased to mention item number 11, 12, and 13, hearing item number 11, 12, and 13. The Lordship, let the matter come up after 3 weeks, Your Lordship,
You're for the,
for the respondent, state
Okay.
respondents, Your Lordship.
you are for the petitioners. Oh. Miss, you are Miss,
Livika, Your Lordship.
and then you are government advocate,
Yes, Your Lordship.
senior government
Oh,
advocate.
Your Lordship, junior government advocate.
Okay, then, government advocate prays for 3 weeks, prays for, prays for 3 weeks time. You have already filed affidavit.
Yes,
Okay.
affidavit is
this
already
is
filed.
okay.
Meantime, how, Your Lordship,
Hmm.
I have to file additional affidavit, Your Lordship, here.
Prays for 3 weeks time to file additional affidavit, to which to which Miss counsel for the petitioner has no objection to stop. Accordingly, the prayer is allowed. List is matter after 3 weeks. Okay,
Your Lordship, I also beg to mention item number 8 on behalf of HIPAA, Your Lordship.
okay.
Your Lordship, 3 weeks will be granted, Your Lordship, for filing counter.
Appearing on behalf of,
HIPAA, Your Lordship, government advocate.
okay. Government advocate means for the respondent,
Yes, Your Lord, for the state respondent, Your Lordship.
state respondent, and then you have no objection. So he need to file affidavit.
Yes, Your Lordship.
Okay, Miss. Appearing on behalf of Mr. You're appearing on
Deepa,
behalf of, okay. Deepa, prays for 3 weeks time to file affidavit,
Yes, Your Lordship.
to which the land counsel for the petitioner, Mr. Alankar. Anungla no?
Toshit Anjan.
Okay, sorry, Pony. Tosit Jan Wagner has no objection to stop. Accordingly, the prayer is allowed. List is met after 3 weeks. Okay.
Much obliged.
Yes.
Yes. If I mention item number 7, kindly grant me 3 weeks time to file my reply. Kindly grant me 3 weeks time to file my reply. Against affidavit in opposition filed by the respondent number 7.
Okay, you are Mr.
RCB lordship.
Mr. RCB, Land Council for the petitioner. Prays for how much time?
3 weeks time, lord.
3 weeks time to file affidavit in reply to the affidavit filed by the
Number 7.
respondent number 7. You are appearing on behalf of the state?
For respondent number 7, Your Lordship.
Okay. The prayer is allowed. Miss
Ali Tosu.
appear on behalf of the respondent number 7. List is matter after 3 weeks.
3 weeks. Lord.
Okay.
Much obliged.
May it please your lordship.
Yes.
Lordship, I beg to mention item number 16, 17, and 18. Lordship, here we have received instruction from respondent number 4, and we will be filing our authority during the course of the day. Kindly allow us some time. Respondent number 4,
You'll be filing what?
our authority.
Okay. Respondent number 4, not yet filed.
Yes, lordship.
You are for the petitioner. Mr.
Mr. Nongwasa on behalf of Nuksong Tila.
Okay, Noxantira. How much time you we are praying for? How much time?
3 weeks, 3 weeks.
Pray for 3 weeks time to file power on behalf of the respondent number 4. Mr. Land Council for the petitioner is also present, and he has no objection to the prayer made by the Land Council 4, appearing on behalf of the respondent number 4. Accordingly, the prayer is allowed. List is made after 3 weeks. Okay.
Obliged, lordship.
May I please, Lordship?
Yes.
Item number 9, Lordship. Here
Yes.
I'm appearing on behalf of private defendant number 6 to 14.
Hmm.
I'll be filing my affidavit today, Lordship.
Okay. You are Mr.
John.
John. The 6 to 14 is private respondent.
6 to 14.
Is a private respondent.
Yes, Lordship.
Okay, Mr. John. Land Council 4. The respondent number 6 to 14 prays for, how much time did you pray?
I'll be filing my affidavit
Today?
today. Yes.
Submits that
The
he's,
government is also a party, state government is a party in this.
submits that he is filing affidavit on behalf of the respondent number 6 to 14 today. So, today. And who else for the government? No, okay. Land Council, Mr. Meadow. Land Council for the petitioner is also present. So when do you want this? So otherwise, the rest of the respondent has already filed their affidavit,
I believe the state government is yet to file their affidavit.
yet to file.
Yes.
Okay. Who appears on behalf of the state? Okay, Miss, you have not yet filed. So how much time you? Miss, appear on behalf of the state respondent and prays for 3 weeks' time to file affidavit. Stop. The prayer is allowed. Accordingly, the list is met after 3 weeks. Okay.
Lordship.
May I please, Lordship? Item 20, Lordship, on behalf of
Item
20, Lord.
20.
On behalf of more information. Can you list this matter on 18, Lordship?
But as fixed item,
On 18th,
18.
yes,
okay. Is prayed for by the learned councils for the parties. List this matter on 18 January
yes, as fixed, my lord.
as a fix, no, 18 January for hearing. Okay, yeah, write the name also, huh? You are Mr.
I didn't know that.
Or Mr. IMT. IMT long chair and line counsel for the petition and Miss
Yes, Your Honor.
is her name, line counsel for the respondent, government, government respondent. Counsel for the state, right, huh? Is praised for by line counsel. Fix on 18, huh? Okay,
My lord.
Lordship. Lordship, I also take to mention item 2 and 3, Lordship.
2 and,
2 and 3, Lordship.
okay,
On behalf of veterans, you know that. Can you choose stand for on the line?
3 weeks,
Lordship.
There's an interim.
there is interim. Miss. So 3 weeks time for what?
Lordship.
3 weeks time for what? Filing affidavit?
Lordship. You file affidavit, Lordship.
Affidavit not yet filed.
Yes, Lord.
Miss so-and-so, land government advocate, prays for 3 weeks' time to file affidavit, to which the land counsel for the petitioner, Mr. You are, has no objection. Accordingly, the prayer is allowed. List this matter after 3 weeks. Okay,
Lordship, similar matter, prayer for item 6, Lordship.
6.
6 on behalf of Peter Juma, Lordship. 3 weeks time to file on the Lordship. 6, 3 weeks time.
3 weeks' time. Who is for the petitioner here?
Lordship, I'm appearing on behalf of Mr. Cynthia. Lordship, there's an interim.
So, okay, interim in the earlier 2 and 3 also there was interim, I think, no? 2 and 3 also there was interim. In the meantime, sorry. In the item number 2 and 3, there was interim. Okay. In the meantime, the interim order passed, others shall continue, huh? Okay.
Lordship,
Here in the item 6, praying for how much time?
I'll be filing during the later course of the week. I'll be filing
You'll be filing what?
affidavit in opposition for respondent number 9 and 10.
9. When?
Today.
Today. And then you are for?
For the state, Lordship. For the state, Lordship.
For the state. State is yet to file.
Lordship.
Okay, you are praying for how much
3
time?
weeks time, Lordship.
3 weeks.
And respondent number 8, I see, and 5, and 8.
Praying for how much time?
3 weeks.
Not yet filed.
Okay.
Okay. The, Mr.
CD rooms,
appearing on behalf of Land Counsel for the,
private respondent, 9 and 10.
okay, respondent number 9.
9 and 10.
9 and 10. Land Counsel for the respondent number 9 and 10. Sami said he is filing an affidavit on behalf of the respondent number 9 and 10 today itself. Mr. Appearing on behalf of the respondent number 8 and Miss, her name, Miss Land Counsel for the state, prays for 3 weeks' time to file affidavit. And for a petitioner, Mr. Land Counsel for the petitioner has no objection to the prayer made by the respondent, the Land Counsel for the respondent number 18. For the state respondent and the respondent number 8. Accordingly, the prayer is allowed. List this matter after 3 weeks. No, you have not yet filed affidavit.
Station councils.
Okay. Learned counsel for the petitioner is asking for the fixed date.
Correspondingly. Must
Asking for the fixed date. When do you want?
15th.
No, not 3 weeks then, Then let this matter is prayed for by the land council for the parties. List this matter on 15/2/2024. You said that there is an interim here? Okay, in the meantime, the interim order pass earlier shall continue. Okay,
Maybe Mr. Lordship, I beg to mention item number 5 on
yes,
behalf of Mr. Sintianger. Counsel for respondent, private respondent number 4. Lordship, here we are yet to file our affidavit reply. Kindly grant 3 weeks time.
no, you are for respondent, you said?
Yes, madam.
Affidavit, you want to file affidavit in reply?
Yes,
No,
Oh.
the counter affidavit there.
counter affidavit.
Counter affidavit? Okay.
My apologies.
You are for the petitioner.
Yes.
Mr.
Manekonya,
appearing on behalf of,
Mr. Sintianger for private respondent number 4.
prays for how much time you prayed?
3 weeks
3 weeks time to file affidavit.
in no process.
To which the land counsel for the petitioner has no objection. According to the prayer is allowed. List this matter after 3 weeks. Okay,
May I please, the Lordship,
yes,
may I be pleased to mention item number 15, hearing item number 15 on behalf of Inaholi State Respondent. Let the matter come up after 2 weeks, Your Lordship.
okay. Who is for the petition?
I have no objection.
No objection. Miss
Libika on behalf of Inaholi
Libika appearing on behalf of Bikoli,
State Respondent.
state respondent. Prays for
2 weeks, Your Lordship.
2 weeks time to file affidavit.
No, Your Lordship, let it come after 2 weeks for
Okay,
hearing.
praise that. Praise that, praise for 2 weeks time. To which the land counsel for the petitioner has no objection. List this matter after 2 weeks.
Much obliged, Your Lordship.
Thank you, Mr. Lordship.
Yes,
I beg to mention here item number 19.
yes.
Lordship, then come after 2 weeks.
As prayed for by the land counsel for the you are for the
I'm appearing
respondent.
for the respondent number 5.
Respondent. You are for petition. As prayed for by the land counsel for the respondent number 5. No, write his name, This matter after 2 weeks.
2 weeks.
Okay. Mr. Inti long chair, land counsel for the petitioner is also present. Okay,
Lordship, similar prayer for item number 21.
yes,
I'm appearing for the respondent.
praying for respondent number
Respondent number 3.
3. Okay, okay, no objection. How much time?
2 weeks time.
2 weeks time. Is prayed for by the land counsel for the respondent number 3. Mr.
Manekonya,
List this matter after
2 weeks.
2 weeks. Miss what? Land counsel for the petitioner is also present. Okay.
Lordship, respondent number 4. I'm appearing for respondent number 4.
Praying for respondent number 4, right? Respondent number 4. Okay.
Deeply obliged, Lord.
Yes.
For motion. Item number 1.
Please, Your Lordship.
Yes.
Petitioner is challenging the 2 OMs, Lordship. Some clauses in the 2 OMs. OM dated 22/9/2004 and also the OM dated 17/3/2015, Lordship. And also praying for a minimum scale of pay as well as regularization, Lordship. Lordship, here the petitioner was appointed in a grade 4 post as Chokida in the year 1997, Lordship. And he has been diligently serving for the last 26 years now, Lordship. So, but he hasn't been regularized yet. He has also written a representation, Lordship, dated 28/6/2023 to the ADC, Bandari, Wokha District, Lordship. However, no response has been made yet. His representation was also forwarded to the DC. However, no response has been made, Lordship. Therefore, the petitioner has come before this honorable court.
For giving you
Lordship,
a pay of a minimum of the,
Lordship, currently the petitioner is receiving rupees 12,430, Lordship, which is a very meager amount, Lordship, being the sole bread earner of the family, Lordship. And he is getting this KP in terms of the ROP 1993 and not the current ROP, Lordship, which his colleagues in the regular posts are getting, Lordship, in the ROP of 2017. Lordship, he's discharging the same duties and responsibilities, Lordship.
you made an
as his
application,
colleagues.
you made
Yes,
an
Lordship.
application for regularization.
Yes, Lordship, my representation is in page number 47, Lordship, dated 28/6/2023. Page 47, Lordship.
Yes.
This is addressed to the ADC, Lordship, Additional Deputy Commissioner. And the application was forwarded to the DC on 28.
You are serving as, on contingent basis.
Yes, Lordship, I was,
Okay.
appointed on
Whether
contingent basis.
whether the authority is maintaining a seniority list of the contingent, employee.
Yes, Lordship.
So
However,
what is your seniority position?
Lordship, my apologies, Lordship, I do not have the list with me. I have not annexed it in my petition, Lordship. However, Lordship, I am aggrieved by the OMs, Lordship, some clauses of the OMs.
Okay.
If I may.
When the OM was issued?
Lordship, one was in the year 2004, and the revised OM is 2015.
Your
Lordship.
2004 OM you are challenging now,
Yes, Lordship.
2004.
Yes, Lordship. Some clauses of the OMs, I am aggrieved by some clauses of the OMs, Lordship. The OM pertains to the, if I may take your Lordship to page. Page 41 is
Yes.
the office name. This is the policy for regularization of service of work charge employees, Lordship.
So you are not challenging the entire OM,
No, not the entire OM,
challenging the-
just
some clauses.
clause 2,
What are those
3, and
clauses?
4 of the 2004.
What is clause 2?
Lordship, it's at page 41.
Yes.
Clause 2 is, may I read your Lordship?
Yes, let us read it.
Clause 2 is regularization of work charge employees will be done against available regular vacancies. Clause 3, 50% of all regular vacancies of similar nature arising in a year will be reserved for regularization of work charge employees, and the remaining 50% will be filled up as per normal rules of recruitment. Clause 4, work charge employees will have the right to be considered first for regularization against 50% of all future vacancies of similar nature in the department for which they possess the requisite qualification. Such regularization will be considered on the basis of seniority cum merit. This means that the senior most work charge employee in the relevant category will be regularized subject to his or her fitness for the vacant post.
What else?
And
Clause,
also the Lordship, and I am also challenging the some clauses of the OM dated
2015.
17/3/2015, Lordship, which is at page 43.
Yes.
May I read your lordship?
Clause 1(1).
1(1). Yes.
Okay.
All existing work charge and casual employees of various departments who are enjoying scale pay and who have completed 30 years or more continuous service as on 1/1/2015 will be regularized by conversion of their posts into regular ones personal to them and subject to fulfillment of conditions as indicated below. A, the
Okay.
incumbent concerned and his or her service rendered as work charge casual employee have been fully verified and found genuine by the district level verification committee constituted by the government. Availability of service records including appointment order, date of initial appointment, proof of length of service, age, etc. C, their suitability for continuation in service to be recommended by the heads of department concerned. The post occupied by them on regularization shall automatically stand abolished as and when they vacate the post on retirement, resignation, death, etc. The strength of the work charge and casual employees under various departments shall stand reduced by equal number concurrently with the regularization of such employees. No fresh appointment shall be made against these posts. On regularization in service, the pay of the incumbent shall be fixed at the minimum of the corresponding pay band and grade pay as admissible under Rule 10 of Nagaland Service ROP Rules 2010. The past service rendered as work charge casual employee shall be counted towards length of service for the purpose of Nagaland Retirement from Public Employment Act 2009 and as qualifying service of the purpose of pension. This scheme shall, however, not be applicable to the part-time casual employees, village guards, home guards, ICDS workers, other CSS paid employees whose services are guided by specific terms and conditions laid by the government and some other categories of contingency employee like personal peons, part-time sweepers, chowkidars, seasonal workers, etc. The period of service rendered as work charge casual employees shall not be counted for the purpose of NVCP. In respect of those work charge and casual employees in scale pay and who have completed or will complete 30 years of continuous service after 1/1/2015, their case for regularization will be taken up consequently in 2 batches as on 1st July and 1st January every year. The procedures and terms and conditions will be the same as laid down in this OM. This existing scheme for regularization of work charge employees against normal vacancy is being modified and the quota for work charge employees stands enhanced from 50 to 67% for the next 5 years effective from 1/1/2015. This existing scheme will also be applicable for the casual employees appointed on full-time basis. Number 2, Lordship, revision of pay, wages of work charge employees. The pay scale of all work charge employees who are presently drawing scale pay as per ROP 1993 and who shall continue as work charge employees shall be revised as under with effect from 1/1/2015, subject to conditions that indicated below. Number 8, there shall be 2 different pay bands and 8 different grades of pay against the existing pay scales as indicated in the table below. The table,
Okay.
there should be a formula for fixation of pay. The existing basic pay in pre-revised pay scale as on 1/1/2015 shall be multiplied by 3.2 to arrive at the basic pay in the band indicated above. The amount arrived at shall be rounded to next multiple of ₹10 to the figure as worked out. Lordship, this is the scale. If Lordship, if I may take your Lordship to the next page, Lordship, 46.
Okay.
Conditions for implementation of the scheme of regularization of revision of pay.
This also?
Yes, Lordship, I'm also challenging.
Okay.
May I read your Lordship?
Yes, please.
Each department shall prepare detailed list of all such work charge and casual employees enjoying scale pay who have completed 30 years or more services as on 1/1/2015 and whose cases are proposed for regularization indicating the name, designation, date of birth, date of entry into service, date of retirement, pay scale and existing total emoluments, pay scale admissible or regularization total emoluments after regularization and additional financial implication. The list shall be certified by the district level verification committee to the effect that the incumbents included in the list are verified and found genuine. Formal proposal for conversion of posts into regular ones to accommodate the employees proposed for regularization shall be submitted by the concerned department first to PNR and then to finance for clearance and concurrence. After obtaining PNR and finance clearance, the departments concerned shall take up the proposal with the cabinet for approval. Only after obtaining cabinet approval, necessary notifications for regularization in service shall be issued. Before releasing the revised pay scales for the regularized employees, the pay fixation statement shall have to be checked by the accounts officer of the concerned department. The pay fixation state and arrears salary statement in respect of all the scale paid work charged employees whose pay has been revised under this scheme shall be pre-audited by the accounts officer and the concerned department. In case where there is no accounts officer, the Directorate of Treasuries and Accounts shall carry out the pre-audit. No bills in this regard shall be entertained in the Treasury unless the same is pre-audited as indicated above. So Lordship,
That means almost entire, this notification. This will,
Lordship.
You are challenging this and this will affect the other
Yes,
employees.
Lordship. So Lordship, 30 years length of service as the criteria for regularization of services arbitrary and discriminatory, Lordship. So this is why I'm challenging the points.
Okay, and then grant pay in the minimum of a pay scale allowed
Yes,
to the
Lordship.
office be appointed on a regular basis.
And also, Lordship, if I may be allowed to make another point, Lordship, the petitioner was appointed on the basis of land ownership, Lordship. So the service of the petitioner should have been on regular basis from the inception, Lordship. I have also annexed the agreements in the petition, Lordship, the land agreement.
Regularize the service. How many years you put on a service you have?
Lordship, I have been serving for 26 years now.
26.
Yes.
Okay. Yes, states.
Lordship, at this point, Your Lordship, let the notice go. Lordship.
Okay. Miss
You see, my Lordship.
Land Council for the petitioner. Issue notice of motion calling upon the respondent to so cause. Why? Rules should not be issued is prayed for. And or why other orders other further order within bracket as orders shall not be passed as this court may deem fit and proper. The notice is made returnable by 4 weeks. Since Miss
Livika for all the state respondents.
appear on
For
behalf
all the state
accept
respondents.
this notice on behalf of all the state respondent. No formal notice need be issued. However, the petitioner shall furnish a required copy of petition to the Planet State Council. within 3 days from
Should be in the course of the day, I will.
during the course of the days. Okay, that's fine. Stop during the course of the days. Stop. Huh? List this matter after 4 weeks. Okay.
Much obliged.
Motion. Item number 22.
Please. Need to, yes. Yes, please.
This revision petition is arising out of a impugned order passed in an appeal before the district judge Dimapur, which appeal arose from an injunction application prepared before the civil judge, who was pleased to reject the prayer sought for by the state. There are two sets of cases. I'll just go into what is actually required because this brief is very voluminous.
Yes, yes. It
Only
fits.
for the purpose of admission, what is required.
Right.
Any other clarification, I'm willing to.
Okay.
One suit has been filed by one Atoshe.
Mm.
That is. Petition number 2 of 2024.
Mm. Yes.
Atoshe was allotted on a temporary basis.
Allotted a lane.
Pardon?
Allotted.
Allotted a piece of land
Okay.
on 22nd October 1993.
Mm.
That allotment is at page 628. 628. I will only refer to a few pages.
Okay.
628.
$628 of the revision petition. This 600. That is another petition. Huh? This is. 628.
Kindly see, we'll start with page 627, just one page before that.
Okay.
May just read one paragraph.
Yes, please.
A plot of land acquired for airport expansion for which land compensation has already been paid is now left out by the airport authority while putting up security fences. As the said area is in the bank of the Diffu River, the land is temporarily allotted to be utilized under the following conditions. One, they shall not claim any compensation when airport requires it. they will vacate the land as and when department authority requires. The litigation starts from here. Second, kindly see page 628, next page. The typed portion is on 629. Kindly come to 629.
Yes.
Yeah. The land under dog number 40 and dog number 38 specified below at the for are hereby temporarily allotted in favor of the following person subject to approval of the government. It's very important. It is allotted subject to approval of the government. And it is a temporary allotment. And we are now concerned with only one, Atosho Seme, serial number 1, A by 40, 9B4K 3LS. So from here, the litigation starts. After this allotment was made, at that time, there were various notifications issued by the government of Nagaland. The said notifications, just keep quiet, no, 1 minute, are at page, some of them, page 633. Got that one, 633?
Yes.
Onwards. I think it goes on for quite a number of pages. We'll keep it, say, up to 648. So these are notifications which say that any allotment of land for the purpose of pata, etc., can be done only with the approval of the government of Nagaland. What was happening? The various deputy commissioners, taking advantage of the fact that they are the issuing authority, started giving land indiscriminately to people for a song. So to control this, right from 1991, even 89, various notifications were being issued, saying you cannot allot land like this without the permission of the government of Nagaland. Thereafter, since this became very rampant, a case arose before a division bench of this honorable court. And that is at page 132. It is state of Nagaland versus Avionilio. Avionilio and others. My lord has got that, my lord?
Yes.
I'll take your lordships straight away to only one page. Kindly see page 161. My lord has got it.
Yes.
We'll deal with para 41.
Yes.
Further to that, a reading of Rule 11 of the settlement rule stipulates that all powers of Deputy Commissioner under the rules shall be exercised subject to any general or special order issued from time to time by the state government. The said rule being relevant is quoted below. All powers of Deputy Commissioners shall be exercised subject to these provisions. 42, this is the relevant portion. Power of the Deputy Commissioner for granting allotment of land in terms of the rules, therefore, in our opinion, is subject to general or special orders issued by the state government. These impute notifications, that is the one which I had read out, come within the ambit of general or special orders issued by the state government And this aspect of the matter was also not taken into consideration by the learned single judge in holding that the impugned notifications were ultra-virus regulations framed therein, for which we are of the view that the impugned judgment is liable to be interfered with in the manner as indicated below. So initially, my lord, this was under challenge before the single judge. Single judge decided against the government. That is how this has come here. Now I draw your lordship's attention to next page, page 43. I'm sorry, para 43, page 162.
Yes.
I will just read two small paragraphs. Consequently, we dispose of these appeals. The judgment dated allowing is interfered with holding impugned notifications are intra-virus regulations and ruled the impugned notifications in order to that extent is set aside and quashed. Next, the order impugned being violative of the office memorandum dated such and such is set aside and quashed. 3. The findings so arrived by the learned single judge of adjudication made in respect to order of such and such as regard the rights of the petitioners in such and such writ petition covered by Pata are upheld. The upholding of the said findings has to be understood only as regards the adjudication from the point of revenue collectors. The directions passed in the order by Deputy Commissioner allowing the respondent number 3 to enjoy his rights over the disputed land on the basis of long-standing and continued occupation of the disputed land would merely be a permission being granted by the Deputy Commissioner to remain in occupation of the land pending allotment settlement made in favor of the respondent number 4. In that view, the allotment made in favor of respondent number 3, respondent number 3 would have no rights as a property land. So ultimately, in this case, the division bench, I had argued this case at the time. The division bench itself confirmed that the unfettered powers are not vested with the Deputy Commissioner. The power has to be exercised with the approval of the government. And so from that time, that has been strictly followed. And it only confirmed the validity and the intra-virus nature of the notifications issued by the government from time to time. Now, why have I referred to it? I'll come to that in a minute. Then again, subsequently, there was total ban on allotment of government land. You can't give it. That is at page 648. Kindly just make a note of it.
Yes.
Then my lord may kindly see page 276, because injunction has been 276. This is from the civil courts judge's order.
Yes, 276.
See page 276. This is actually a portion of the Specific Relief Act amended in 2018. The schedule. I will start with section 41. May I read it, sir, right from the top.
Yes, please. Sir.
Injunction when refused. An injunction cannot be granted if it would impede or delay the progress or completion of any infrastructure project or interfere with the continual provision of the relevant facilities related thereto or services being the subject matter of such project. Schedule. Serial number 1. Second column is category transport. Third column is infrastructure projects. In infrastructure projects, fifth below at E is given airports. We are coming to that. So according to the Specific Relief Act, you cannot grant injunction in respect of infrastructure projects, and in that airport has also been included. Here the injunction has been granted in such a way that we cannot go ahead with the infrastructure project, which is the airport. That is the ultimate, the encroachers are permitted to stay there. Now I come straight to what is the view of the Supreme Court on this? Kindly see page 97. I won't take your lordship to any further page as far as this petition is concerned. Page 97.
Yes.
This only shows how much importance is given. Got that?
Yes.
NG projects versus Vinod Kumar Jain and others. Kindly see page 117. My lord, it's 117. Para 19.
Yes.
The specific relief act was amended by Central Act and section 41 was added. 41HA, it would impede or delay the progress or completion of any infrastructure project or interfere with continued provision of relevant facility or serious services being subject matter. Sorry. Such amendment was in pursuance of the report submitted on such and such by the expert committee. The expert committee set on examining the specific relief act, submits its report to Union Law Ministry and recommends a modification. Expert committee set on examining the specific relief act, and the Minister of John in his report has recommended modifications for doing business. Now, this is the actual reason why this was amended. In the context of tremendous developments which have taken place in '63 and the present change scenario involving contract-based infrastructure developments, public-private partnerships and other public projects involving huge investments and changes required, the present scheme of the Act so that specific performance granted as a general rule and grant of compensation or damages for non-performance remains an exception. Now, I just pause here for a moment. Up to the time this amendment took place, like if you're doing some infrastructure project, maybe on somebody else's land, whatever it is, the rule was specifically performed. Now, if that man's property is there, you can't touch it. Compensation was the exception. By virtue of this amendment, what has happened is compensation became the rule. Specific performance became the exception. Because of this only, now we have so many metro projects, so many highway projects, 4-lane, this lane, that lane, everything. Why? It's an infrastructure. It is meant for public, for the use of the public. Now, just because somebody has a right over it, not that he should go empty. He can ask compensation if he proves that that is his land. Whatever is the reasonable compensation, all the states in India are giving. So because of that, now infrastructure project is going. Now, I just continue from, for non-performance remains as an exception, the committee decided to change the approach from damages being the rule and specific performance being the exception to specific performance being the rule and damages being the alternate. Then, to provide guidelines for reducing discretion granted to the courts and tribunals while granting performance and injunctive release. To introduce provisions for the rights of third parties. To consider addressing unconscionable contracts, unfair contracts, reciprocity, and implied terms. The committee observed there is a need to classify utility contracts as a distinct class, recognizing the inherent public interest, importance to be addressed in the Act. Any public work must progress without interruption. This requires consideration whether court's intervention in public works should be minimal. Smooth functioning of public works projects can be effectively managed through a monitoring system and regulatory mechanism. The role of courts in this exercise is to interfere to the minimum extent so that public work projects will not be impeded or stalled. Since the construction of road, here it was a road construction, it's an infrastructure project, keeping view the intent of the legislature and the infrastructure project should not be stayed. High Court would have been well advised to hold its hands to stay the construction of infrastructure projects. Such provision should be kept in view even by the writ court while exercising its jurisdiction under 226 of the Constitution of India. So Supreme Court is giving a direction to the High Court and also saying even the constitutional reliefs under 226 also you should keep in mind. Because it's only because of this we can progress. If everywhere there is going to be an injection, we will be like what we have been before, so that the country catches up with other nations and public get the benefit of science and technology. The act was amended and Supreme Court is clearly giving a caution not to do it because in the beginning, not knowing or whatever it is, some casualties could be there. To prevent it in future, court has said this. Now, when all these points were raised before the civil court and also before the district judge, when it was specifically mentioned, you cannot give land pattas without permission of the government. There is a division bench order of this court. Then the land has been acquired by the government from the public and partly leased out to the Airport Authority of India. Notifications have been issued for both DAG number 38 and DAG number 40. These two DAG numbers may be noted. DAG number 38, DAG number 40. And instead of, when they sought a stay, they should not have been granted stay. They were encroachers. They had no title deeds. I have one volume on title deeds that I'll deal with if required. The court said, unfortunately, that these people, how much people? Only 1 dozen. Huge area. Construction is just a few houses. We have surveyed all this. That we should not disturb them because they are staying there. As far as the airport is concerned, the court said, planes are taking off and coming, so no problem. Our runway is very small. Dimapur. They want to extend the runway. Why do we want to extend the runway? In Mangalore, not Bangalore, Mangalore, sea coast. There is a runway like Dimapur, short. About 10 years back, the plane skidded and there was a major accident. So when we are going to face that calamity, we do not know. Apart from development, it's a question of safety of the public as such. The court has to see the interest of the public, not the interest of a few encroachers. Presume for the sake of arguments, they want to ventilate their right. They have specifically said, you give us compensation, we will go on affidavit. But you will get compensation if you prove your title. We cannot give otherwise, to be fair. And unfortunately, in this case, I don't know why it has occurred. I have not seen that. Must be a terrible mistake. I won't make any imputation against any judicial officer. There is an observation because Airport Authority of India is a party. There is an observation by the court that the Airport Authority of India, to whom we have leased out, is not keen on going ahead with the construction until the title dispute is sorted out. Shocking. They have made various complaints to us, saying these people should be vacated. From where this has come, I do not know why it has come, but it's my duty to point out. That is on page 136. Page 64. Page 64.
Yes.
I'll start with para 26. Para 26 is another judgment of the Bombay High Court, which went to Supreme Court. Again, on this type of infrastructure. And the learned judge has quoted that. That's the interesting part. He has not suppressed anything. He has quoted it. That is at para 26. I'll just read out. A word of caution ought to be mentioned herein that any contract of public service should not be interfered with lightly, and in any case, there should not be any interim order derailing the entire process of the services meant for larger public good. Now, how they have dealt with it. The instant case, that's our case, is not with regard to contract, but for the rights title of the suit land. Whereas the appellant submits that the land has been acquired for expansion of airport, it is seen the plaintiffs and the transferees are in physical possession of the suit on the basis of valid land pattas issued by the competent authority. Stop. I want to just make one solution. So the basis on which injunction has been granted is patta has been issued by the competent authority, overlooking the fact that this authority has to get permission from the government of Nagaland. And various notifications have been issued, which have been filed pending before all the courts, along with the division bench order, which says they don't have authority without the permission. So this very finding that they are in physical on the basis of valid land patta, that is wrong. Next, this is where I said, I don't know how it has come, the next slide. As such, the Airport Authority of India would also first like to clear the doubts with regard to title before starting any development work. It is the Airport Authority which wants to construct. They have got nothing to do with title. Property is only leased out to them. Property is leased out to them. They are in a hurry. State government responsible will give the land. Now, a finding of this nature without anything on record. How can they say that? So I don't know. That's why I say I'm not making any comments, but kindly make a note of this. Well, this is unfortunate. I would restrict my comments only to that. So by this wrong interpretation of valid patta, and then they are questioning, the government has to prove that it acquired the land. Government has to prove it gave it to them. It is a title suit by the plaintiff. Plaintiff has to prove the title. Suppose the plaintiff discharges its obligation, only then the defendant comes into the picture. plaintiff has not been able to discharge its obligation. And the learned judge is saying, you prove your case. And in these acquisition matters, it is general law that once certain proceedings are taken, the property vests with the state.
What is the status of the case pending before the civil judge at the moment?
At the moment, it's like this. They filed the application for injunction, restraining these encroachers from being evicted. The court granted that permission to them. Effect of that being, contrary to NJ Construction's judgment of the Supreme Court, contrary to Section 41HA of the Specific Relief Act, they have granted the injunction.
Injunction is, they have filed a separate application for injunction.
They have filed, both the parties have filed separate applications for injunction.
That has been disposed of.
And the learned judge granted the injunction.
Mm.
And unfortunately, the district judge simply copied down what is there without any application of mine.
Upheld.
This is one point of it. And one of the findings, now I come to the next point here. So this chapter is over as far as one party is concerned.
Now, what about the title suit? I am asking.
Yeah.
That status of the title suit, the main suit in the civil judge.
That is lying there.
At what stage?
It is at the same stage of filing. It is the injunction application which is being contested.
Okay.
And I am saying, say for the sake of arguments, notwithstanding the fact that they don't have title.
Whether the written statement filed in the title suit? In the title suit before, the civil judge.
Yes.
Written statement already filed.
We have filed.
Issue framed?
No.
Not yet.
Not yet.
Hmm.
Now what is the next issue? This allotment which was given to this party in 93
Yes.
was cancelled in 95, and I went 2005.
This was placed before the landed.
Yes,
Okay.
2005 it was cancelled.
And this cancellation order was not challenged.
Final.
Hmm.
Then he files the civil suit for the same area which was cancelled. And the case doesn't stop there. I'll come to the next point. He doesn't say he sold the property to anybody. His case is comparatively a smaller issue now. He is no more also. His legal representatives are before the court. Now what he says, one Vinoka comes into the picture. That is the second petition. What is that? That is Civil Revision 1. That's another file. It's a big file.
Okay.
But we need not worry about that file. He comes in the picture in 2016. 15. He is now the main contesting party. What does he say? He says, I purchased the land from Atoshe. And in support of that, he files sale deeds. It's very interesting, sale deeds. The sale deeds which he has relied upon pertain to another area, not this area, that is called Ekrani Pattar. And there is no privity of contract between him and Atoshe. Those sale deeds have been introduced by this man in 2016.
Atoshe is the present respondent.
Atoshe is the respondent in the first case,
Okay.
and Vinoka is that is in this case.
Hmm.
Atoshe was a plaintiff there, respondent here. Vinoka is the second plaintiff. He filed a separate suit. He didn't ask for title because he has no title, only declaration of some commissioner's order passed in 2019 with regard to a separate land. So now Vinoka says that I purchased the land through sale deed, he admits it. You have to overcome the fact that title deeds do not pertain to the area which they have encroached. He says, the surveyor told me, you put the name of Ekrani Pattar, so I put it. There are at least 140 pages of about 13, 14 sale deeds which are on record. I will give the page number, like this. So he said, that's why I did it. If you see section, I'll just show one sale deed if you don't mind. Kindly see that big volume. I'm sorry to trouble you, sir. No problem. This is in, I can take it from Atosha's case itself. Yes, we have filed it in that case also.
Okay.
So we need not travel far.
Hmm.
This you can see, sir. From say page number 705. And this is 705. You have seen the sale deed, sir?
705, yes.
Yeah. So it is very clear, whereas the vendor is situated at Ekrani Pattar.
This is sale deed.
Sale deed.
Yes.
So it pertains to Ekrani Pattar, different area. And the sale deed is not between Atoshe and this person. The seller is somebody else. Sheloko Yepto.
This is situated at Ekrani Patta.
Correct.
Pathar.
But that's a different area. Now,
What is the name of the present area?
it is Dipupar. Dag number 38 and 40.
Okay.
Now, sir, I will just draw your attention to section. Can I follow? Section 92 of Evidence Act.
Okay.
Section 92 of the Evidence Act says, I'm just forwarding steps here. Section 92. Section 92 says, There's no change in the law.
Hmm.
Section 92 says,
Hmm.
if there is a written contract, you cannot lead any oral evidence to the contrary. Can you say?
Hmm.
Section 92
Hmm.
says, exclusion of evidence of oral agreement.
Hmm.
When the terms of any such contract, grant, or other deposition of property or any other matter required by law to be reduced in the form of a document have been proved according to the last section, no evidence of any oral agreement or statement shall be admitted as between the parties to any such instrument or their representative or interest for the purpose of contracting value. So it is his own document. He has filed this document. Now he wants to say in his pleadings that the surveyor told me. Now the basic position here is they initially challenged certain notifications issued in 2019 by the commissioner. This pertained again to Ekrani Pattar. But they were encroaching and sitting on dark number 38 and 40. Since the orders went against them, they went to the High Court. Same case. High Court heard the matter. In the High Court, these very people made statements on affidavit that they have nothing to do with dark number 38 and 40. Plus, they also said, our land is at Ekrani Pattar. Therefore, the High Court passed an order. You have your injunction in Ekrani Pattar, whether the title deed is right or wrong. But we are going to modify that injunction order that as far as dark number 38 and 40 is concerned, we will not grant you injunction. I will take you, sir, to 3 pages of that. That is that page. Page 834, sir. I'm sorry, the other brief. That is also there in our sir.
Five, 6, 3 came out.
Okay, I think in our brief also it is there. I think it is a.
800, eh? Oh, don't mix up.
Okay, then you can just see there. Just. Civil Division 2, no?
800.
819 of October. Eight one nine, sir. Associate, sir.
Okay. State of Nagaland versus
Yeah.
Vinokachisi.
Right. So this is the order. I won't take lordship to this order. Same issue. Now we come to the relevant portion. Page 834.
Yes.
Now, there is a High Court finding on the same thing. Prima facie case, balance of convenience, irreparable injury, everything. And how it modifies the order. Para 11. May I read?
Yes.
On asking the court as to whether the land allotment order issued in the name of Atushe was for the land under dock number 7996 at Ekrani Pattar or the land under dock number 38 and 40 of Dishupur area, the learned counsel representing the opposite party writ petition submitted it is for the land at Ekrani Pattar. So they are admitting before the High Court. Then there are three things one must look at while considering the case for temporary injunction. Whether petitioners have a prima facie case, balance of convenience or irreparable loss. 13. Coming to the first point, it appears from the documents and the submissions of the learned counsels that whereas the actual land under dispute are dock number 38 and 40 of Difufar village, the land allotted to Atushe from whom the others are claiming to have acquired right and title under dock number 7996 of Eknath Pattar. It is obvious that the opposite party petitioners can claim right and title only in respect of the land under dock number 7997 situated at Ekrani Pattar and not over the land under dock number 38 and 40 situated at Difufar. The opposite party cannot gain anything by saying that it is the respondents who issued the allotment letter. Therefore, in mentioning wrong name of the location of land allotted to them would not make any difference because they have been in possession of the actual land allotted. It is for them to verify and confirm that the document bears right particulars of the land they are supposed to have been allotted. They cannot claim right and title for the land at Difufar on the basis of an allotment order or any other land. To conclude, it may be stated that the said allotment order and subsequent orders of mutations were issued rightly or wrongly by competent authorities. The opposite party writ petitioners had a strong prima facie case to go for a hearing in respect of dock number 1790 at Ekrani Pattar, but not for land under 38 and 40. In other words, opposite writ petitioners have a prima facie case in regard to land under 7997, not 38 and 40. 1. 2. On the second question on which the balance of convenience lies, it follows from the conclusion drawn that even if one is to assume that the opposite party have been in possession of the actual land in dispute, that is dock number 38 and 40, the balance of convenience cannot be on their side since the documents based on which they are claiming right and title are in respect of land situated at Ekrani Pattar and not dock number 38 and 40. Balance of convenience can be claimed only by one in legitimate possession, not by anyone else. On the other hand, learned AG has submitted that the lands under dock 38 and 40 at Difufar are situated adjacent to Dimapur and the same were leased to the airport and the latter is in urgent need of the same for the much needed expansion and development of the airport, weighing the interest of the individuals and the public interest. This is very important. And on the scale, it is obvious that the public interest would tilt the scale. Moreover, from the writ petition, the opposite party are not totally opposed to development work, provided they are given compensation. The question of compensation can still be considered. We are ready. Even after the disposal of the main petition, while the development cannot be held back for a long time. For the aforesaid reasons, I am of the view that balance of convenience in respect of land under dock number 38 is not on the side of the opposite party, but on the writ petitions. Coming to the last point, as to whether the opposite party would suffer irreparable loss in case they are removed from the land in question, it would be obvious from what has been stated above in the preceding paragraph, more particularly because of the fact that land for which they are seemingly having right and title at Ekrani Pattar and not on the land of 38 and 40, no irreparable loss is likely. It may also be mentioned that learned AG had even submitted that petitioner is not going to do anything in regard to land under 1797 at Ekrani Pattar for the time being, but only prays for modification of the interim order in respect of land under 38 and 40. As stated already, the opposite will have no right of claim in case they are successful in showing. No, I'm sorry. as stated only, opposite party petitioner will have the right to claim compensation in case they are showing their title over such and such. In view of that, I am of the view the interim order can be modified. Status shall be maintained only in respect of 38 at Ekranipatra and not for dog at 38 and 40. Now, after this order is passed, a very sad thing. Exactly after 1 week, they withdraw the writ petition. They say we want to file fresh petition, permission granted. And then they go before the bench and tells the court, very innocently, we will approach the civil court. Because the court had already given a finding, you got nothing to do 38 and 40. Ekranipatra you go. So in that intention, the court said, yes, you go to the civil court. When they go to civil court, what do? Because they don't file appeal against the order of the High Court. They plead wrong facts, saying we are owners of dog number 38 and 40.
No different.
And then they get an injunction for 38 and 40, which the High Court declined.
Same person.
Pardon? Same persons. Just imagine the extent. The High Court passes this order. After the High Court passes this order, they go to the civil court because they said, see, High Court has given us liberty. The liberty granted by the learned judge. He had already given a finding that you have got nothing to do with 38 and 40. Go to Ekranipatra. You prove your title. There they take a somersault. They say we are owners of 38 and 40. There was a communication gap, etc., etc. And after placing all these facts, injunction has been granted for 38 and 40, confirmed. This is what, in a gist, I have many more things to add, but I think suffice it for the moment.
No, but you see, your claim here,
Sir,
so if granted, it would amount to a final disposal.
no, no. What I am asking now is very simple.
Hmm.
What I am saying is, because we have not issued notice to the other side, coming up with the question.
Yes. Hmm.
Notice may be issued, number one.
Hmm.
Meanwhile, these orders will be stayed because they are completely in violation of Supreme Court directions. They are given in violation as far as infrastructure projects are concerned. And what does the Supreme Court say? I'm talking of an extreme view. This is a general view. What will happen to the suit? In the suit, as it is, I have stated the fraud which I have played so far. Presume for the sake of something, anything. What are they claiming on affidavit? You give us compensation, we will go. This is the case. And what does NJ construction say? You can't stop construction. Now, compensation is the rule, specific performance is the exception. Is this such an exceptional case that specific performance should be given? And this person who has done this, who has brought these titles, he has not filed a title suit also there. They have simply sought the declaration of certain orders passed by the commissioner. So these are things which have to be gone into in detail, for which I will have to address many more legal points also. For the moment, this is what we wanted last time also. In the light of the fact, division bench has clarified on various things. And just one more point which I shall, with your liberty, read out. Kindly take out the case of, what's his name? Vimoka. That is a big bundle, sir. Page 79. I think it's page 79. Just see it. There's a limit. Let us got that, page 79.
Which case?
page 79.
Of
Oh,
civil division two,
yeah. One,
one.
the big file.
Yes.
I will just read how the court has dealt with NG Con. Last paragraph. Keeping, what is it?
Hmm.
Keeping the aforesaid principles in mind, learned civil judge went on to observe that a perusal of the pleadings as projected in the plaint by the respondent in their suits, the respondents who are 14 in number, including performer respondent 14, that is Atoshe, are presently housed at the suit premises with their families, which implies that there are structures, buildings standing on the suit land. Keeping in mind the present status of the respondent, vis-a-vis the urgency of the appellants in ensuring that the land is vacated, that is vacated of carrying out development work for expansion of the airport, which is for public interest. If you have to balance these two aspects, scale of inconvenience leads more towards the sides of the respondents, as the impact being dispossessed. In the instant case, 1 minute. I'm sorry, sir, I went to on the side of as the impact of the injunction prayed for, if not granted, is going to be felt by more by them. Further, less inconvenience will be caused to the appellants as the development work has not been initiated. Complete violation of the findings of NJ construction. They are saying if you are balancing public interest with that of a few householders, we cannot destroy them. Public interest will be sacrificed. I don't understand. Or is it they have not understood the judgment? I don't want to say anything, but it's unfortunate. Therefore, in my respectful submission, this is not a case by which they can take the state for a big somersault. No. To prevent that, Specific Relief Act has been amended. And in accordance with the Specific Relief Act, Supreme Court has passed clear directions, even to the High Court, don't grant injunction. Apart from that, a division bench of this court, the writ court, has clearly said that they have no right over this. And behind the back of the High Court, they go to the civil court. They take a somersault. Don't challenge the High Court order. Again ask for dog number 38 and 40. And the court gives the injunction in favor of them, which means the project is now stalled. So these matters will have to be gone in this revision petition itself. There the interpretation will come of NG constructions as to whether compensation is the remedy, is the rule, or specific performance. Supreme Court has given its verdict very, very clearly. And imagine this person, this Civil Revision 1, he has not filed her title. He doesn't have title. It's basically, sir, all said and to be very frank outside this, it's a bunch of encroachers who are now bargaining with the government to get some compensation. They can have their bargain. We are not against it. But should the airport suffer? So all these facts have to be gone into detail in the petition.
That is the detail. I think it has to be heard, of course,
Yes.
as early as possible.
Early, any day. I agree. We don't want to take any advantage of these orders being stayed, or it's not that overnight we're going to do anything.
Yes.
We are government, we are responsible. Another responsible authority is the Airport Authority of India.
But the prayer, if granted at this stage, would amount to the final disposal.
No, I am only saying this. For the moment, where notice be issued to them.
Yes.
These orders are all violative of all what I have said. I'm not repeating. They be kept in abeyance. 3, to see everybody's interest is protected. That civil suit will remain stayed. That will not proceed. Give early date, we'll finish. Nobody's rights affected. It's not, we want to take any
No.
advantage.
Stay with amount to, because the order itself is to maintain status quo only.
Pardon?
The order of the civil judge and the district judge is to maintain status quo.
Yeah, the order is basically
Basically,
giving them,
yes,
no, that is not this, because they are saying we are in possession.
yes.
So they are saying status quo means you remain in possession. What we are saying is, we are not going to disturb anybody, let's be clear about it. What we are saying is, this order, if kept alive, in my respectful submission, that would not be showing respect to the higher courts. I don't want to say anything more about it, because I feel that something has gone wrong somewhere. Whether they have not understood the impact of these things. Then as far as maintaining the purity of the suit premises is concerned, like they say, the structure should remain. Act has changed, and let it, we have to accept the fact that act has changed. You cannot grant this type of injunction. And the court, and we are not
No.
taking any advantage.
What the injunction say exactly? What the injunction exactly says? To maintain status quo only?
No. Yeah. In view of the foregoing, I hold
Page
329,
329,
please.
page. Civil revision 1.
Yes.
Yes.
As such, you got it. As such, once permanent structures are set up in the suit land, it will cause irreparable loss and injury. Then, in view of the foregoing observations, I hold plaintiff petitioners have satisfied the three golden principles for granting temporary injunction in their favor. Accordingly, civil miscellaneous such and such granting injunction favors the plaintiff, restraining the defendants from evicting them and obtaining possession until disposal of so. So they have given a very clear injunction.
See, performance eviction order.
Yes. So what I am saying is, we don't proceed with the suit. In fact, sir, earlier, I just want to clarify. I want to clarify. Initially, against the order of the civil judge, the state filed directly a revision petition in this court. According to procedure, we should first file an appeal. Against that only you can come in revision. Having realized this inadequacy, state sought liberty of the High Court that we will approach the concerned court to file the appeal. That's how we filed the appeal and we have come back in revision. While the revision was pending, High Court also passed the order that stay of the suit. Once the suit proceedings are stayed, it takes care of everybody's interest. So they won't have this feeling that I'm going to throw them out. We won't have this feeling that they're going to do some other thing there. That will satisfy the purpose. Keep these orders in abeyance and only say, as far as the civil.
No, what will be the implication if the orders are stayed, kept in abeyance? Then the eviction order that is shown, say, will proceed?
No. Two orders are there. One is the eviction orders, I mean the orders passed by the courts below, impugned orders. One is stay of those orders. Two, as far as the civil suits are concerned, until the disposal of this revision petition, they will be stayed. Fair. Nobody's interests are affected, then we can have opportunity of hearing this matter at length.
So civil suit be stayed,
Stayed.
proceeding of the civil suit.
So that means I cannot evict them. Two, these, as far as these impugned orders are concerned, they are kept in abeyance. And civil suit is stayed until the disposal of this petition. And keep an early date for this. So that this revision petition is decided.
Is it a part of a prayer?
Pardon, sir?
Prayer,
Yeah. Interim application. We have got that, sir. Page 12.
yes,
First is impugned order 29/9/2023 passed by district judge to stay. Second, impugned order 22/11/2000 by civil judge. Then last, proceeding of civil suits 14/2020, and in the other stay application, it is 20/2019. They also be stayed. That's all. We have taken care of it while looking into it. No prejudice to anybody, no advantage to anybody. Law will prevail.
so you mean to say that we do not touch with this, the injunction
Sir,
and only the civil suit pending before the civil judge be stayed?
there are two civil suits.
Yes,
One is, that is civil suit number 14 of 2020. The other case, it is civil suit number 22 of 2019. Two suits. Both the suits will stay, and the other orders are virtually same time. We have given the details in each stay application.
so the implication of staying the civil suit would be that you will not proceed with the,
Nobody will proceed with the suit. It is their case. Suit has been filed by them.
okay.
So suit will not proceed. Then as far as these orders are concerned, by both the courts, they are kept in abeyance. Then it becomes a complete order.
What in the civil in this case? Number such.
I will put it this way.
Yes.
What is it we want to do?
Restraining, just a minute, restraining the defendant's opposite party free from executing the aforementioned eviction order dated so and so. and obtain possession of the suit, land, thereunder, planning disposal of the suit. Okay. So this was passed in injunction or application only.
So one order, I have the dates with me. The magistrate or civil court order is on 22nd November 2021. 22nd November 2021.
Civil judge order.
Civil court. 22nd November 2021. And the district judge order is on 29th September 2023.
Okay, district judge order is 29.
Correct.
And then the civil judge order is
22nd November 2021.
so these two order will not touch for the time being.
Sir?
These two order
Sir?
will not touch or interfere for the time being. Not pass any order.
No, we are not saying anything. We are only saying,
Ah.
sir, just, I want to make one point. here.
Yes. The 22nd, 11, 2021.
What I am saying is,
Civil judge order is 22nd, 11, 2021.
yes, that is the initial stay order
Hmm.
passed by the civil court. And by the district judge, it is 29th September 2023.
Okay.
Sir, you have got that, sir?
Yes.
Now, I just want to clarify one point.
Hmm.
Maybe what's troubling your lordship is,
Yes.
maybe what is weighing in the mind, will it amount to the disposal of this? No. Once we are saying the suit remains stayed, everything comes to an end. Why I'm saying you keep this in abeyance is that these orders are, because this is a constitutional court, they are in direct conflict with the Supreme Court directives. You recollect, if I am just speaking off the record, about 2 weeks back, the Supreme Court passed an order. Incidentally, that order was passed by our recent former Chief Justice, who has been elevated, where he issued contempt notice to the magistrate or civil judge for clear violation of orders, when everything is explicitly clear. I personally feel that as far as this case is concerned, I am not able to understand. Perhaps it may be an erroneous understanding of these things, right? That fear might be there. What will happen to the substratum of the case? Initially, when a new law comes, it has teething problems. But this amendment came in 2018, and Supreme Court directives are very clear. Just to see that there is absolutely no difficulty on that question, I'm only requesting humbly that as far as this order of the district, that is as far as the civil court order is concerned, once we say they will not proceed, that amounts to a stay. One is it. Then as far as the district court order is concerned, only mention that is kept in abeyance till the disposal of this. It's a complete order. Everybody is protected. It's not my intention to create any problem for anybody. That's not my intention. I'm seeing the law, utility of the law, and to see we get justice. It can be done that way.
The parties. In the order of the district judge, the parties are directed to appear before the civil judge on 2010. Appeared.
Appeared, we have taken date, that we are challenging it. And even the jurisdiction of the civil court to entertain this case.
Hmm.
We are covered by a special act. I have not gone into all those details. We are covered specifically by another act which prohibits civil court interference.
So
But
now you are not praying for stay of the order passed by the civil judge and the DJ. Only you are asking for staying of further proceeding of the title suit.
Why?
You are praying for
Of the district judge's order.
district judge's order.
Yes,
But that amounts to, you see, district judge's order upheld.
he appeals it. So we have to stay that district judge's order because
Hmm.
why we have to stay it?
Hmm.
Here is an order that is being passed against a Supreme Court judgment. What is the caution given by the Supreme Court? You will not grant injunction. The Supreme Court is not disturbing the suit. Suit will remain. Suit will remain in any event. Question is, should we wait for the complete suit to be disposed of at different stages for several years? Or can we, after this is decided, go ahead with the construction? Suit will decide whether he has got title. He will get compensation. That is the law. It's not that he will go empty-handed.
No. The stay of the district judge order will amount to stay of the civil judge order.
It makes no difference.
Hmm.
It makes no difference because the civil judge, while passing the order, says, if you compare public interest with the general interest, then the interest of these people will have precedence over public interest, unheard of. Can one such order be kept? It should be kept in abeyance. It should be kept in abeyance, my lord. I am saying this with all my, after going through everything very deeply. How can they pass an order unheard of? And we are giving the judgment to the court. And they are avoiding to answer that question. Therefore, in one such situation, this honorable court should protect the perpetuation of these type of orders. Otherwise, the Supreme Court may pass anything, statute may pass anything, but a civil court and a district judge will pass whatever they want. That will not be in order. That requires correction. This honorable court has got.
Violation of which Supreme Court order did you say?
My lord,
Violation of which Supreme Court order? This order of the district judge is a violation of which Supreme Court order?
of NJ Constructions.
NJ Construction.
Because NJ Construction says clearly,
Hmm.
it says you cannot grant injunction. And second judgment says, we are cautioning you, don't do it. And they are cautioning not the civil court, they are cautioning the High Court acting under 226, don't do it. When they are cautioning the High Court, and this matter has come to the knowledge of this court, that they are violating this type of order, actually stricture should be passed against them. I am not asking for that.
I haven't gone through that. What I'll do is, we'll issue notice
Sir,
and this injunction will consider on the next date.
sir, no, sir. Kindly bear with me.
Hmm.
There should be no hesitation in this type of cases.
Hmm.
This is the High Court.
Hmm.
We are not passing any strictures.
Of course, this case
We are not passing any strictures in
needs
this case.
hearing, here, needs, early hearing, of course, I understand.
No, what I am saying is,
Hmm.
I don't find any plausible reason why they should not be stayed. When the
That's
court,
true, that's true. But,
no, the only apprehension is
hmm,
perhaps weighing in your Lordship's mind.
hmm.
Would it amount to disposal? As far as the main suit is concerned.
Hmm.
This is what was weighing in the mind of those courts. That is why the Supreme Court said, you shall not grant injunction, not only Supreme Court. Statute says,
This,
can I read it again, sir?
hmm,
I'll read it again, if you permit me.
no, just,
We'll just read it once more, then I leave it to you.
which one?
That NJ Constructions, the relevant portion.
Okay.
I just 2 paragraphs. I won't take it. NJ Constructions is in the other case,
Civil Division 2.
and yes, page 161. I'll read it. If you are not convinced by my submission, I'll leave it. I am only pleading in the interest of justice. I have nothing else in it. Just wait here. Wait to the page. Which is the page? I just, some confusion is this one. Okay. The para 19, sir. Page 117. Kindly have a full reading of this. If for any reason this honorable court is not convinced, I will leave it. You see, the order passed by the Supreme Court is a command under 142. Kindly see this. We should respect this. May I read it, sir?
Page 117,
117, sir, para 19.
para 19. Just a minute.
May I read it once, sir?
Yes.
The specific relief act was amended by Central Act in such and such. I already read out the specific relief act. 41 HA. I have read this separately. It is there in our specific relief act. 41 HA gives that airport is one of those infrastructure projects. Now, what do they say? It would impede. 41 HA says, actually it says no injunction will be granted if it would impede or delay the progress or completion of any infrastructure project or interfere with the continued provision. If you see 41 HA, which I have read out, I think at page 276, it says no injunction can be granted. And then they have reproduced only this portion. Such an amendment was in pursuance of this report. The expert committee set on examining the specific relief act and submitted the report. Expert sent on examining the relief act to the Union of India Ministry of Law. In its report, the committee recommended following modifications. Now I read again. In the context of tremendous developments which have taken place since '63 and the present change scenario involving contract-based infrastructure developments, public-private partnerships and other projects involving huge investments, specific performance granted as a general rule and grant of compensation or damages for non-performance remains as an exception. Kindly mark this. To change the approach from damages being the rule and specific performance being the exception, to specific performance being the rule and damages being the alternate remedy. The very first sentence answers the question, what will happen to the soup? You will not get specific performance, you will get damages. If it's an infrastructure project, 41HA is a statute made by the parliament. Second, to provide guidelines for reducing the discretion granted to courts and tribunals while granting performance and injunctive release. Limit their discretion. It is not an unperturbed discretion like before. To introduce provisions of rights of third parties, etc. To, all right. Then now come to para 21. You got that, sir? Since the construction of road is infrastructure project, keeping with the intention of the legislature, the infrastructure project should not be stayed. The High Court would have been well advised to hold its hand to stay the construction of the infrastructure project. Such provision should be kept in view even by the writ court while exercising its jurisdiction under 227 of the Constitution. So what more clarity is required? What more clarity is required? They cannot be treated with soft gloves.
Now you see, the stay was granted by the civil judge
Sir.
on which date? Long back,
Right.
long back,
22/11/2021.
21. Since 21, it has been stayed.
Sir? I didn't follow what you said, sir.
No, this, since 2021, the operation or it has been stayed by the civil judge since 2021.
No, what has happened? Just
Hmm.
after that, what has actually happened here, they had come to the High Court. The parties had come to High Court. What is the date? So they had come to the High Court here.
Hmm.
So they filed first petition, they filed a second petition.
Hmm.
Then they got the liberty and went there. So after they went there, before the civil judge, the arguments were heard. Then against those things, we are here back. So the case has been circulating. Now, ultimately, when the civil judge passed his order, we came to the High Court in revision petition.
Now, after civil court pass an order,
We have come by way of, we have come by way of that in the form of a revision. I will just give that order in just 1 minute.
against the order passed by the civil judge.
Yes. Kindly see
What was the order there?
page 178.
Criminal Division 1, Civil Division 1.
It is there in both. I will just give. This is civil division. This is 263 of civil division 1.
Two, 6, 3.
Yeah.
Hmm.
The operative portion is page 271. And this is an order passed on 8th May 2023. Got that, sir?
Yes.
I'll just read it. Heard during the AG and
Page 271. Yes.
271.
Hmm. Yes, please.
Heard the concerned council. Next page, sir. Where is it? Just take off. I'm not getting it. I'll just read 272. This civil revision petition was filed under 115 with 227 dated 22nd November, passed by learned civil judge in such and such of civil suit number, whereby the learned court granted interim injunction in favor of the respondent. I have perused the details on record. I have also perused the affidavit and opposition filed by respondents, whereby the respondents have raised a plea. Civil root petition is not maintainable, and appeal ought to have been filed. Learned AG has submitted that no reply against the affidavit has been filed by the present petitioner, and they are relying on the earlier documents which are filed with the relevant petition. Learned AG fairly submits that under the facts and circumstances of the case, the only available options are either to convert the present revision petition into an appeal, or to withdraw the present revision petition with liberty to file the appeal in an appropriate form with a time given by the court. Learned counsel does not object to the said prayer. In view of the facts, as well as submissions, learned AG, the revision is allowed to be withdrawn with liberty to approach the appropriate court. The time consumed in pursuing the petition shall be excluded. With these observations, revision is given 3 weeks time to approach, civil dismissed. Accordingly, within 3 weeks, we filed the appeal before the district judge. When we filed the appeal before the district judge, on 3 occasions, the case was adjourned for whatever reasons. Either the counsel was not there, and then it was listed for judgment also. And even the dates of judgment were adjourned 3 times. And that is why the order was passed in September. Even then, it was quite a quick disposal, because it was passed here. What is the date it was passed? So there is continuity of what is happening. So why I say is, everything is explained, sir. I didn't go too much detail. Yeah. Yes. Yeah. Even in para 6 of my civil revision petition 1, I have given very clear details. Judgment was to be delivered. Then it was deferred 3 times. Then we didn't get the copy. All these things are there. It's not that they passed the order and we were waiting all this time, no. And during the period when it was in the High Court, there was stay of the suit. There are too many applications, too many petitions. I try to make it brief to the extent possible.
Yes.
Otherwise,
That is why,
to introduce this case itself will take a long time.
yes, yes.
I tried with my whatever resources to make it in this short time. Though the Honorable Court has asked relevant questions which I've tried to clarify. Sir, if I may say so,
Yes.
Supreme Court has taken care of a civil suit in the very order. NJ Constructions. What they are saying is, at the cost of repetition, they are saying he may be entitled to compensation. I'll give the example. Delhi Metro is going on. Metro is going on in different places. Like here, Arunachal, Assam, Nagaland, Meghalaya, all these northeastern states, we are having slowly 4 lane. There are some pinpricks by landholders from time to time, we want this, we want that. But what is the responsibility of the state? Pay the compensation. Compensation is being paid actually by the central government, isn't it? But what is the essence? You cannot get stay. If you get stay, and if the parliament passes a law, the stay would defeat the intention of the parliament. So to reinforce, the Supreme Court is in its jurisdiction under 141 and 142 saying, don't grant injunction. They have granted injunction. I am not asking for anything more than that. Keep it in abeyance. That's fairness. That means this court has understood certain aspects of this. Keep it in fairness, no observations. Everything will be disposed of on a date fixed by the court.
No, what I'm saying is by keeping it in abeyance would mean that the stay of the order passed by the civil judge.
Civil judge's order is patently wrong, number one.
No, that is true. That will be decided only later on.
That is wrong.
Decided final. So, what we can do is we can expedite the final hearing.
No. That will be completely in violation of this court order.
Hmm.
I'm saying with respect,
Hmm.
as far as the civil court is concerned, the civil courts have been informed about these things. You can't stay. You can't grant injunction.
But then it is subsequently the district judge also upheld.
That the district judge is not the Supreme Court.
No, that
The
is true.
the
That is
district
true.
judge has to comply with the
Whatever-
Supreme Court
whatever
order.
whatever may be, rightly or wrongly, but it has upheld.
So does it mean it is final?
No, that is not a final. So
That is why I have come here.
To decide that, we need to inform the other side also,
Yeah, no,
give an opportunity,
we'll do like this, because something is troubling the court's mind.
right?
I don't want to
Yes, that is
use
right, that
any
is right.
pressure on it.
That's all, otherwise nothing.
So what we'll do,
Give an opportunity to.
we'll do like this.
Yes,
Let notice be issued.
right.
2,
Hmm.
meanwhile,
Hmm.
the proceedings pending before the civil court will remain stayed.
Okay,
I think that is the fairest way.
so that is what I am saying. Okay.
What do you say?
Hmm.
Proceedings, that will be in accordance with what the High Court did earlier.
So, in the meantime,
In the
in the
meantime.
meantime, okay.
I'm grateful for this long hearing.
Yes,
I only try to, I've toned down my arguments in this case. In a case of this nature where they didn't show respect to the Supreme Court directions, only on this presumption that they might have committed some mistake. What else can I say?
Mrs. And Advocate General. No? Okay, Government Nagaran, assisted by Miss.
Liberty be given to us, sir, to serve the councils. We have approached them.
Hmm.
They said, let the court, let it come before the court. They were present here also earlier.
Okay,
I may be given liberty to serve the councils also. Because some of these people are difficult to catch. I don't want time to be wasted.
okay. Issue notice. Returnable by 4 weeks. The petitioner shall serve copy. Shall take steps upon the respondent within 3 days. Steps within 3 days.
Pardon, sir?
Steps within. No,
We will supply everything.
okay,
We will supply the state. So how much time you are giving us?
How much time you want?
I think we won't take more than 1 week. I'll see to that it is done.
1 week, within 1 week, huh?
I'll see to it.
From today. By a registered post with ID card.
And also service to council.
Liberty is also given to the petitioner to serve a copy to the land council for the respondent. Land council for the respondent.
Basically, I think that should suffice because they have been appearing, they were present.
Okay.
They were given she told them that
Hmm.
you take the copies.
Hmm.
They said, let the court pass
Okay.
orders. So
Okay.
let the notice go to them,
Okay.
the councils.
Hmm.
We can give it Dusty. We'll go and hand it over.
Okay.
Best is that we'll give Dusty notice. Council, we don't require registered or anything. Notice to council, Dusty will hand over everything.
Given to the land to serve for Dusty to the land council for the respondent. Okay.
All the respondents.
All the respondents.
Because even Airport Authority of India is also in this case.
Hmm. We'll say that we are not passing any order in your IA, but then in the meantime, the proceeding will stay.
We just say that as far as the civil proceeding, the suit proceedings are concerned, both the suits,
Hmm.
they remain stayed. That's all.
Okay.
That is the least we can ask for.
That prayer you have made in the IA?
We have said civil suit, prayer C.
We'll also say that the interim, you want to be considered on the next date, interim? No.
No. This is it, because next stage, we want it disposed of.
Hmm.
We don't want to have a long innings in this case. People sitting on government land and dictating terms with the government. We want them evicted.
By the way, what would be the implication of this staying of the proceeding of the civil suit?
Civil suit stay means that remains stayed. We are not going to proceed. Suppose, I'm saying, civil suit is not stayed. Suppose it proceeds for whatever reason. That will come in conflict with the matter which is pending before this court. It has to be stayed. This High Court has stayed it earlier.
We'll say till returnable date?
Pardon?
We'll say till returnable date? This, the proceeding of the civil suit before the civil judge will be kept in abeyance
No.
or stay?
That will remain stayed
Stay.
till the disposal of this revision
Till
petition.
disposal
This is the higher court. This order has been passed earlier also.
Earlier order do we have?
It is in the earlier records, but record my statement as Advocate General, if you want. I have no problem. We speak the truth. Unlike these people who have been changing their colors in the documents and capturing public land.
The proceeding of civil suit numbers. One is 14 and one is
Correct. 14 of 2020 and 22 of 2019. 14 of 2020, that is Minoka's case, and 22 of 2019 Atosha's case.
Okay, having regards to the contention with regards to the contention made and the submission made by the learned Advocate General, Government in Nagaland. In the meantime, the further proceeding of civil suit number 14, 2020, pending before the civil judge, Senior Division, Dimapur, shall remain stayed. Stop. List this matter after 4 weeks. Okay.
I'm very grateful.
In both, huh? Both the cases. Okay.
Very grateful. Where it's very difficult to handle a case
Yes.
where there are so many angles at each stage.
Yes, and this, I had no occasion, of course, to go through also.
Yes.
I
That's
never
very
thought that
difficult.
this will be so bulky.
Very difficult. That's why I
Seeing a
tried,
small one,
I tried to make it as brief as possible.
Mm.
Because otherwise it will take the whole day only for notice.
right?
I'm obliged.
One listed admission, WBC 186 of 2023.
This lordship, my lord, this case is regarding the contract matter. And therefore, we would like to withdraw this matter to file afresh.
Afresh.
To file arbitration petition,
What petition?
arbitration.
Arbitration petition.
Yes, Lordship.
Your good name, please.
P. Momini is
Miss P. Momini. Now, counsel for the petitioner wants to withdraw this writ petition with liberty to file arbitration petition, if so advised. Arbitration petition before the appropriate forum. Stop. The prayer is allowed. This petition is dismissed on being withdrawn with liberty as sought for. Okay.
For hearing, item number 14.
That is Lord. If I have instruction to appear on behalf of Mr. Cynthia, the counsel for the petition.
Yes.
So the counsel is having some difficulties, so can you let the matter come up for 2 weeks?
Okay. You are for
I'm for respondent number 5, the accountant general.
respondent number 5,
Yes, lordship.
and you are for state, no? Mr. Your name is not there? Okay, Mr. Appearing on behalf of Mr. Satyangar, land counsel to the petitioner. prays for 2 weeks' time. To which the learned counsel for the learned state respondent, Miss so-and-so and Miss
K. Lilisu.
for respondent number 5 has no objection. In view of the above, let this matter be listed after 3 weeks, 2 weeks. Okay.
For hearing, item 24.
May I please, Lordship? Lordship, I'd like to mention on behalf of my engine Lordship, if this matter can come up on 18 yes, Lordship, on Thursday.
Okay. You are for?
Yes. Additional.
Okay. Miss. Learned government advocate appearing on behalf of Mr. Moim Chan, Learned Senior Government Advocate, praise for listing this matter on 18th.
18, Lordship.
To which Miss Learned Counsel for the petitioner, Miss S. Jelian has no objection to stop. Accordingly, the prayer is allowed. List this matter on 18th for hearing. Okay.
Applies, Lordship.
Finish. Okay.